In this episode, we're going to look at why you're not getting anywhere with rejecting a faulty vehicle you bought from a car dealer on finance and what it is you can do about it. In my experience, there are 4 common reasons why people struggle to reject a faulty car. The first is they're simply directing their complaint to the wrong person. The second is they've not properly set out the legal basis for their complaint. Third, the car dealer or the finance company or their lawyers simply don't understand their legal obligations to you. And fourth, well, they're just being obstructive. When you buy a vehicle from a dealer on finance, it's the subject of a triangular arrangement where the car dealer sells the car to the finance company, who in turn sells it to you by way of a hire purchase or a PCP agreement. In short, the contract for the purchase of that vehicle is with the finance company and not the car dealer. And it's to the finance company who you should direct your complaint. Now, that in itself may go some way to explain why it is when you've complained to the car dealer, they've ignored you, they're disinterested, or they've just given you the brush off. Even more so if you're actually trying to reject the car. What you should do is this. Firstly, you should get some sort of documentary evidence that proves the nature of the fault that you're complaining about. It doesn't have to be an expert report in the truest sense of the word. It could be diagnostic testing report from the likes of Quick Fit, Halfords, the local garage, anyone like that. You have to bear in mind that just because there's a dashboard warning light on your car, that in itself is not demonstrative of the car being faulty. Once you've got that evidence, it should be sent to the finance company with a covering letter expressing the basis for your complaint and your rejection. Now, I'm not a big fan of these standard letters that you can download from the internet, from Citizen Advice, Trading Standards, or Which Magazine, for example. They're just simply too generic. They all mention the Consumer Rights Act 2015, whether or not the vehicle should be satisfactory quality or fit for purpose. They're just not specific enough. And like anything, when car dealers and finance companies just get the same letter all the time, it just loses that impact. So in my opinion, you should send an email. It doesn't have to be complicated. It should be formed of 3 distinct paragraphs. The first paragraph should set out the basis of the contract that you have with the finance company. It should go something like this. Dear sir, as you know, I purchased the vehicle registration number XYZ from you on such and such a date for the sum of so many pounds by way of a finance agreement number 12345. The second paragraph should set out what we call the breach facts, the information that you are relying upon to ultimately get what you want to reject this vehicle. And that should say something like this. On the such and such date, the vehicle suffered a breakdown, resulting in it being recovered to a third-party garage by the AA, which the diagnostic inspection revealed had a engine failure, gearbox failure. Please see attached diagnostic report. And the final paragraph just simply should say what it is you want the finance company to do about it. For example, as a result of the matters referred to above, I reject the vehicle, requiring you to unwind the finance agreement and pay to me all the sums I've paid to you under that agreement. And that's it. Now, in doing that, that will trigger the complaints process prescribed by the Financial Conduct Authority. And that means the finance company have a maximum of 8 weeks in which to investigate your complaint and to provide you with a final written response. Now, if you don't get that final response in 8 weeks, or the response you get is not what you want, that's to say they don't uphold your complaint and you remain dissatisfied, then you should phone Stormcatcher Law on 0333 7676. Thanks very much for watching.